Hi guys, so I'm making a video regarding Judge Cindy Pánuco mentioning in her rulings that she's giving me an extremely lenient treatment. Extremely lenient treatment, and she's saying that I don't deserve an extremely lenient treatment. Okay, so let me show you her extremely lenient treatment. Okay, I have filed March 20, March 26th, May 5th, May 7th, May 12th. I've appeared in front of her 3 times, May 5th, May 7th, May 12th. And before that, I filed 2 ex partes in which she did not accept my appearance, though I did appear by telephone on March 20th. And on March 26th, I appeared by LA Court Connect. She did not even come to speak to me. So, anyways, you can see this on March 20th, the first time, and after a lot of fear, a lot of anxiety, I filed something in the court because whenever you file something in the court, you have this thing in mind, this thing in mind that, okay, you actually may be wrong, if it goes against you, and, the courts don't consider that, but it is in the litigant's mind. So see what she says. First, the application does not comply with California rules of the court. Which rules of the court? She mentioned which rules? The California Code of Civil Procedure. Which court's civil procedure? The local rules of the Los Angeles Superior Court. Which local rules? Or the basic principles of due process? The court must hold all litigants who appear before the court to compliance with the California rules of the court, the California Code of Civil Procedure, the local rules of Los Angeles Superior Court, and due process. Plaintiff's ex parte motion seeks relief that must be requested by a regular notice motion. Okay, so she here is asking for a regular service motion, and rest of the things you can read yourself. And in the same hearing, she said the ex parte application is denied without prejudice to file a regular notice motion that complies with all deadlines, the California rules of court. But she's saying California rules of court, but she's not mentioning which California rules of court. And she's saying that she's extremely lenient with me, but till date, she has declined all of my motions. None of the motions are accepted. None of the ex partes are accepted. Okay, so let's go on the other one. This was on March 26th. So she was on vacation on March 24th. So this was continued to March 26th. Okay, here is the important part. The court further orders that on grounds that plaintiff Suchan Gupta has been declared a vexatious litigant. She's again and again pointing out on vexatious litigant to insult me and to make me feel bad, despite knowing the fact that 4 out of 5 cases were settled in the vexatious litigant motion. One was never filed. Mr. Brainard never served me the papers, and Judge Wyndham, he did not give me extra time which I asked to file the paperwork in the court regarding this. So she says he's prohibited from filing any new ex parte applications from today's date until an order to show cause hearing the court will hold on May 5th, 2025 at 9:30 a.m. Okay, so this pre-filing order came back because the court said that there is no order that I cannot file the motions. So this I have shown you in my other videos. This pre-filing order came back. Okay, and then furthermore, there is something more you can read. Person to inherit authority under Civil Code of Civil Procedures, Section 120, Subdivision A8, 1, to amend and control its process and order so as to make them conform to law and justice. The court sets an order to show cause why and all future filings by or on behalf of Mr. Gupta in this action should not be subject to order issued by October 14th, 2024. Pursuant to that order, plaintiff is deemed a vexatious litigant. See again, vexatious litigant, again and again, again and again, again and again, to insult me and she wants me to stop filing anything. She is not letting me file anything. She's so angry and so prejudiced. Okay, anyway, so this was March 26th. Okay, now we are going to May 5th. Okay. Moving forward, plaintiff is to lodge in person. See, direct, So this was my first hearing with her. And see, moving forward, plaintiff is to lodge in person any and all non-appeal related documents in this action. The document proposed for filing must be lodged in clerk's office located on the second floor of the Street Courthouse. The court in Department 26 will review all documents lodged with the clerk. The court in Department 26 will determine whether they comply with the California rules of court. Which California rules of court? Oh my God. So see, I am telling her all the frauds of Mr. Brainard, okay, fake notice of sale, SSN, and whatever I've told you before, and she is blocking me from e-filing to exhaust me. Can you see that? This is on May 5th. And see further here. However, since the court said the order show cause, plaintiff alone has electronically filed over 70 additional documents. You tell me if the opposing counsel is doing big time fraud, sending letters, emails, threatening emails to my real estate agent and his escrow broker, and he's sending me a fake notice of sale, filing 4 writs in 4 different cities in the California court, filing duplicating liens on my property. What am I supposed to do? Okay. While some maybe tried to notice motion, the court found it incredibly difficult to discern that due to lack of compliance. Which compliance you're talking about, Cindy Pánuco? The court finds there is a little effort made by plaintiff to follow rules. Which rules? Except when a particular rule provides otherwise, the rules of civil procedure must apply. Which rules of civil procedure? Okay. Finally, to the extent the plaintiff has filed documents preparing this order which are not properly captioned and titled, all the documents are captioned, Judge Cindy Pánuco. The court cannot consider those. Moving forward, plaintiff documents must be lodged in person, must be tied to a notice hearing. Wow. The motion hearing number, the motion of hearing the document is tied to date and time of hearing. Wow. Plaintiff argued that the pre-filing order was burdensome and he could not financially afford to drive to the court to manually file documents. He requested that the court permit him to mail documents. The court denied this request without prejudice. Wow. Look at this. Okay, this is very interesting. Final ruling. Based on the notice of withdrawal of notice of sale, which defendant filed on March 26, 2025, and the declaration of counsel submitted with the documents OSCRE notice of sale by Mr. Brainard, Christopher and Brainard, license number 199444, which I am saying, declaration of a notice of errata filed on April 14, 2025. The court finds and orders as follows. Defendant's notice of sale filed on February 28th has no basis in the law and is hereby stricken from the docket in this case. The court further admonishes defendant that all future filings by defendant must be supported by the law and must be noticed to take into account the pre-filing order that subjects plaintiff filings to review period of 14 days. So see, so she has put me under review of all of my filing for 14 days. Why? Because I am reporting all of the frauds of Mr. Brainard. Failure to give adequate notice or to file documents not supported by the law or the rules of procedure will subject defendant to an order to show cause regarding why defendant should not be sanctioned pursuant to California Code of Civil Procedure Section 128.5. So guys, looking at all the fraud of Mr. Christopher M. Brainard, California bar license number 199444, just this, can you imagine? Do you think only this is enough? I don't think so. Only this you think is enough? Just this little admonishment? No, there is no way that this is enough. It should have been more. Like, he should have been sanctioned and he should have been reported to the California bar. Plus, he should have been disciplined. And nothing of that sort happened. This is a slap on the wrist. This is zero.